David Brock is going first. All right. Short opening statements from each of you, and then we'll go to rounds of questions.
All right. Thank you. Good afternoon, Mr. Chair, members of the committee. Thank you for the invitation to appear before you today. In my opening statement, I will address only those aspects of the bill that may have the most adverse effect on electors in the Northwest Territories. Those are the end of vouching, the examination of identification documents by candidates or their representatives, and limiting the communications of the Chief Electoral Officer of Canada. Voter ID laws in the Northwest Territories mirror those in the Canada Elections Act. Therefore, this makes for valuable comparative study. Following the 2011 territorial general election, the Legislative Assembly concluded voter identification requirements did, in some cases, discourage qualified voters from voting. The requirements do seem somewhat excessive, particularly in our smaller communities where we all know each other. In the 2011 territorial election, for every 1,000 ballots cast, 15 electors required vouching. Even though the population of Yellowknife is more than 5 times greater than the next largest NWT community, vouching was twice as likely to take place at a polling station in a community other than Yellowknife. The reason is apparent. In 27 of 33 NWT communities, less than half of residents hold active government-issue photo identification. This causes me to draw 3 conclusions. First, the frequency with which vouching occurs is relatively low. Second, electors in smaller NWT communities are more likely to rely on vouching in order to exercise their right to vote. And third, in my view, removing vouching from the Canada Elections Act would, at least in the short term, cause a barrier to access for some electors, especially in our smaller communities. The claim that vouching increases the risk of fraud is, in my view, unfounded. Consider the process. First, the person vouching must have proper identification, and the person being vouched for must provide basic personal information and swear an oath. As the Parliament of Canada considers eliminating vouching, the Legislative Assembly of the Northwest Territories is contemplating expanding vouching by recognizing the relationship of electors beyond the polling division, as well as by increasing the maximum number of times an elector may vouch for another elector. I ask this committee to recommend removing the provisions of this bill that repeal vouching. The Parliament of Canada is also considering allowing candidates and their representatives to examine an elector's identification at a polling place. It is important to have partisans monitor activity at polling stations to ensure that the electoral processes are carried out in accordance with the law. However, it is equally, if not more important, that ballots be cast free from intimidation or undue delay. To restate, in 27 of 33 NWT communities, fewer than half of residents hold active government-issue photo identification. Almost all of the approved additional documents that may be used as proof of residence are likely to contain personal financial information. The risk of unveiling personal financial information to a polling official, especially in small communities, is already a possible deterrent to voting. I am concerned that this deterrent will be exacerbated if these documents may also be examined by partisans. The riding of Western Arctic had a 53.9% voter turnout during the 2011 federal election. Along with many other northern ridings, it falls near or below the bottom 10th percentile for participation rates in federal elections. Allowing partisans to examine an elector's identification may, for some, be intimidating and inhibiting, and thus could cause even lower rates of participation in Canada's north. I ask this committee to recommend removing the provisions of this bill that allow candidates or their representatives to examine elector identification. Finally, the summary of this bill clearly states that it is an objective to limit the Chief Electoral Officer's power to provide information to the public. With declining participation rates, it is not clear why it would be a policy objective to have fewer election-related messages. Under current federal law, the Chief Electoral Officer may implement public information programs, and I'm quoting, particularly for those persons and groups most likely to experience difficulties exercising their democratic rights. One such group is Aboriginal peoples, who comprise 51% of the population in the Northwest Territories, and whose participation in federal elections is already significantly lower than average. We know that the decision to participate turns on a sense of civic duty and a minimum level of political resources. Political parties and candidates are very well placed to offer political resources, but partisans are not necessarily interested or incentivized to convey a sense of civic duty to all eligible electors. It is the Chief Electoral Officer of Canada who is best positioned to answer for all Canadians why voting matters. I'm concerned that limiting the information provided by the Chief Electoral Officer may have a disproportionate effect on Aboriginal electors in Canada, a group of people who comprise a majority in the Northwest Territories. I ask this committee to recommend removing the provisions of this bill that limit the power of communication by the Chief Electoral Officer of Canada. That concludes my opening statement. Thank you, Mr. Chair.
Thank you, Mr. Brock. Mr. Archer, opening statement.
Well, I thank the Chair and members of this committee for inviting me here this afternoon. I'm Keith Archer, the Chief Electoral Officer of British Columbia, an appointment I've held since September of 2011. Prior to this appointment, I was a professor of political science at the University of Calgary for 27 years. Bill C-23 contains more provisions than I can address in the short time available to me. Consequently, my comments focus on two themes that go to the heart of some of the key provisions of the bill and which were discussed by the minister responsible in a newspaper article yesterday. They are voter identification and the accessibility of the ballot, and secondly, citizen engagement in the electoral process. Let me start with voter identification and the accessibility of the ballot. Because Canada does not maintain a national citizen registry or issue universal national identity cards to all citizens, the federal jurisdiction and many provinces have adopted some variant of the same framework to provide proof of identity and current residential address for voting. That is, a Type 1 document, which is a government-issued identity document with photograph, name, and residential address, or two Type 2 documents, one of which has the person's name and one of which has the name and residential address, or the Type 3 process as a fail-safe mechanism, which is the use of vouching. Bill C-23 makes it more difficult to satisfy voter identification requirements by removing the voter information card from the list of approved Type 2 documents and by eliminating vouching, the fail-safe method. I would encourage a rethinking of both of these changes. Only about 85% of Canadians possess a Type 1 identity document, such as a driver's license. For those 18 or 19 years of age, it's about 60% and falling. For those over 65, it's about 70%. Type 2 documents are necessary to ensure that the millions of other eligible voters who don't have a current driver's license can still exercise their Section 3 Charter right to vote. The list of Type 2 documents that are approved is quite extensive. The independent, nonpartisan Election Administration Agency approves Type 2 documents, usually following extensive discussions with various service providers to ensure that classes of voters are not administratively excluded from voting. We recognize that these documents, considered individually, are imperfect. Requiring that voters produce two such documents increases one's confidence that they establish that the voter is who he purports to be. And this is added to other checks in the system, such as having voting taking place in a public space, providing candidates the opportunity to scrutinize the voting process and to challenge voters on their right to be registered and to vote, hiring election officials from their local communities, and levying substantial penalties for voter impersonation. The Type 2 identification requirements strike a balance between proof of identity with certainty while ensuring an accessible ballot. The only document on the Type 2 list controlled by the election agency is the voter information card, or, in the case of British Columbia, the Where to Vote card. as we focus our efforts on continually improving the quality of the voters list, we continue to improve the quality of the VIC, or the Where to Vote card. The other identification issue in Bill C-23 is the removal of the vouching procedure. In the 2013 general election in British Columbia, vouching was used by about 14,000 voters. Just under 1% of all votes cast were by voters who were vouched for. Our analysis reveals that vouching is more common in rural districts and in mixed urban-rural districts. There is no doubt that vouching adds complexity to the voting process in BC. And since the election official overseeing this process only receives 3 hours of training on all aspects of voting administration, we recognize that there may be minor administrative errors in completing this process. But let's not confuse minor administrative errors, such as a voter not signing the vouching form in the right place, with the election fraud. An analysis of administrative errors in vouching in BC's 2013 election showed that fewer than 1,000 such minor errors occurred among the 1.8 million votes cast, and there was no indication of election fraud in any of these cases. Simplifying vouching procedures can dramatically reduce error rates. But the bottom line to vouching is this: vouching allows tens of thousands of voters in BC and hundreds of thousands of voters in federal elections to exercise the franchise for which their citizenship entitles them. There is no evidence, of which I am aware, that links vouching provisions in Canadian elections with voter fraud. And there are many safeguards in place to ensure that this is the case. Let me talk about citizen engagement briefly. The last point I wish to make concerns citizen engagement in Canada's electoral process. In British Columbia, Elections BC is the province's window into the world of election administration. We are the people who are engaged to think about these issues every day of the year, to understand current research, trends, and best practices in other jurisdictions, and to ensure that expertise benefits our citizens and provides the best advice possible for policymakers. We have a particular role to play in removing barriers to participation so that all eligible electors can exercise their franchise. At times, this can mean focusing extra efforts on citizens who face substantial barriers, more substantial barriers than their neighbours. The right to vote is not diminished because a citizen is young or a new Canadian, or because they recently moved and their identity documents have not been updated. It also means that we have a role to play in fostering public discussion about electoral matters. I was very pleased recently to head a panel in British Columbia that issued a report to the Legislative Assembly regarding the issue of internet voting. We benefited considerably by previous work of our colleagues at Elections Ontario and Elections Canada. We also recently collaborated with the Centre for the Study of Democratic Institutions at UBC on a conference on the 2013 BC election. All of which is to say that there are a number of groups that have an interest in fostering the democratic process. Political parties and candidates, civil society organizations, scholars, activists, and not least of which, election administration agencies. Indeed, our election administration agencies in Canada are the only group that are specifically designed to take an independent, nonpartisan approach to citizen engagement. I would encourage the committee to reconsider limiting the role of Canada's independent election agency from this important work. Elections Canada's current and past work stands as an international exemplar of election administration best practice. With that, Mr. Chair, I'm happy to turn the floor back to you.